All right, everybody, welcome to the
Yeah,
Creative
push it back.
Finance Collective. We are here to answer and talk about all things creative finance. With us, we've got Scott Horne and Sean St. Clair. Maybe we'll get another couple others to join us. We will see, but we're here to take questions for the hour and address any creative finance questions that you have or real estate questions that you have. So make sure to be a part of it. We'll be on here for an hour until we stop getting questions. So if you want us to stick around, we want your questions. Go ahead and provide it to us. A couple housekeeping notes. If you're watching on Facebook or any other platform other than YouTube, you'll notice a barcode at the top of the screen. Scan that. That'll take you to our YouTube channel, which is the easiest place to interact with us. Go there, subscribe, like the channel. We'd really appreciate it. Scott, you're in Scottsdale. What are you doing in Scottsdale?
Frying. Unlike somebody who's up in, the north, up in Canada almost, I think.
Yeah.
And nice, cool, and comfortable. But you ask yourself, why in the world does anybody come here in July, August, or whatever it might be?
Yeah, it's brutal.
It's hot. In Texas, you used to always say about frying an egg on the sidewalk and those kind of things. Yeah, I think you'd burn it.
Yeah, it's no longer a good breakfast here if you keep it on there too long.
Oh, yeah. You walk outside, and I'm used to heat in Texas, and you can go, you go like to Houston, places like that, and you get all the humidity, where it's just like it just drips on you immediately. And we were talking earlier, Andy. You walk outside here, you don't sweat, you don't do anything. I think this evaporates automatically. But good Lord, you get out into a concrete pavement area or something, that radiation, wow.
Yeah. So, Sean, what's the temperature in Wisconsin right now?
76 degrees, at least where I'm at.
Can you hear the thoughts I'm sending you right now?
Yeah. Scott, I bet they have an emoji for it. If you can figure out that, you can just send it to them.
Oh, they have one for it. Trust me.
But talk to me in January or February, and
Sean, you won't be there in January or February.
I will. Yes, I will.
Really?
Unfortunately, yeah. So we have a. Long story short, but our youngest decided that she wants to go to high school here, and she did not end up getting into the school in Arizona she wanted to go to, and so here we are.
Aren't you the parent?
Permanently. Yeah.
What, did you say permanently?
At least for the next 4 years.
Oh my goodness. We'll send back a lot of cheese.
I can do that. In fact, on the 4th of July, they had a little parade in town. And the biggest hit was when the cheese manufacturer came by chucking cheddar cheese to everybody, wrapped slices of cheddar that they're throwing out.
Oh my God. Now I'm thinking about, what's that old movie called, Doc Hollywood?
Oh,
with
man,
Michael J. Fox in it.
Fox.
And they have, was it the Peach Festival or the Squash Festival or what? Same thing. That's what I'm kind of visualizing where he is.
Yeah, there you go.
How big is the town where you are, Sean?
Huh?
How big is the town where you are?
50,000. So
we call that a suburb.
I know. Yeah. So 50,000. Then we have some outer lying areas that are, I would say the Sheboygan County Metro is probably 70,000, 75. And we're about an hour north of Milwaukee, an hour south of Green Bay.
And Andy, why didn't you get the message for the shirt color today?
Well, yeah, we should put you two on a side-by-side shot. That is, now that you bring it up, if I'm being honest, it's a little creepy. And it definitely clashes with the red and white background, Scott. What were we thinking?
It does. Well, you can't see the turquoise shorts I have on either, okay?
Well, the viewer can't. I had the pleasure of seeing it.
You can hear me coming instead of see me, right?
Yeah, exactly. All right, everybody. We're just shooting the bull here, as they say, but we do have a question. If you're just now joining us, this is the Creative Finance Collective. So we're taking questions on creative financing and talking about all things creative finance. And we have here Sean St. Clair, Scott Horne, and myself to do that. So first question, beyond the purchase contract, what do you think is the most important document in the subto transaction? Or do you think it's even dangerous to classify one document as more important than the other? Because, of course, that suggests that the other ones are, maybe you can do without them or something.
Well, let me make the first comment. I'll let Sean then walk all over me, because I'm going to disregard the mortgage documents, because that's just common sense, okay? Because I think you've got to have your deed and your deed of trust there to protect the seller. So I think in any creative finance transaction, the most important documents are the disclosure documents. I think 90% of this business is disclosure between a seller and a buyer. It doesn't matter whether it's a subject to from a seller to investor, which is what most are, or to a homeowner, or even it's a wraparound mortgage from an investor to a back-end buyer. Ensuring that the seller, and I'm going to guess say the investor too, have full and complete disclosure in writing of documents where they have a chance and an opportunity to review those documents, consult with, an attorney should they wish to do so, which they never do. They may consult with a realtor, which kind of becomes an issue because they don't understand it. But I go back, guys, years ago when no one was doing this stuff. And what scared me was I knew that sellers would never read their paperwork. I knew that back-end buyers would never read their paperwork. You give them, I have 19 pages of disclosures for a buy or a sell, where it might be, that we work with. And each one is there for a reason. I compartmentalize them for a reason, in a certain way, knowing the attitude of sellers and buyers out there. But I took one step further, because in our closing packages that we do, I go back through and I redisclose a great majority of this stuff. And I actually say things, I repeat myself, on several occasions, and I do it intentionally. And I say things in a different way, just because I don't want a seller to come back on the investor down the road and go, wait a minute, you didn't tell me about X, Y, or Z. Because what happens is sellers have short-term memories. They always think that the investor is supposed to pay off that property in 6 months or a year or 3 years or whatever it might be. They forget that so often the investor comes into play. They have rescued the seller out of foreclosure so often. But I have always felt that disclosure at time of contract, redisclosure at time of sale, just to ensure that, you give everybody as much opportunity as possible to review, ensure they know exactly what's going on, again, eyes wide open into the transaction. Because I feel if you do that, what I've always said is, if you have a willing seller and a willing buyer with full and complete disclosure, you wind up with a good transaction. Don't tell me that it's illegal or you can't do it for some reason or do on sale, or it might be. But if you do proper disclosure out there, I think those disclosures, the contract is the contract, in my opinion. I like to recommend state promulgated forms whenever possible, and then supplant that with proper disclosures along the way. Some people don't necessarily adhere to that. They still use these ridiculous 1, 2, 3 page contracts sometimes. But so when I look at that, the question, disclosures to me are number one most important document or documents for these transactions.
What about you, Sean?
Yeah, I agree. In fact, that's what I was going to say, is the disclosures are the most important after or in conjunction with the purchase contract. I actually want to change the subject a little bit. I've been hearing rumblings about some stuff going down in Texas with proposed legislation and other things that's going to impact the investor community and, potentially, seller carries and wraps and that type of thing. Are those
don't believe
accurate?
Well, let's back up. So
Okay.
yes, it's accurate.
Okay.
It is proposed.
Okay.
They tried to run it in under the radar. Imagine that. It is not necessarily earth-shattering, and I'll explain why. Whenever we can keep the government out of our back pocket, I am a fan. But at the same token, when you have a lot of bad actors in the industry, ergo the need for legislation, right, to protect the consumer and things of that nature out there. But also, I'm gonna say it's kind of akin to, I don't know the name of what the requirement is, but it's the national registration of corporate ownership that's out there.
Oh yeah, the CTA.
Is that what it is? CTA?
Oh.
Where, I've been schooled on 2 or 3 separate seminars now on the requirement about that. And of course, each one says, yeah, it's unconstitutional, this, that, et cetera. Now here in Texas, when you file your franchise tax returns, guess what you're also disclosing? Your corporate ownership.
Right.
And that's to Texas. And I'm sure if the Fed wanted to get information from Texas, they could, maybe.
Well, yeah, but they don't want to compile their own data. They want us to do it for them.
Probably. And the liking was when they were trying to get gun registration out there. No, they captured 200,000 names of gun owners before it got declared unconstitutional. So, of course, my position on that in Texas is I ain't turning nothing in until probably December the 26th or 7th, because I have until then to do it. And I've already heard that it's been taken up on appeal now, and hopefully it'll be overturned so we don't have to deal with it. We'll see where that goes. But sorry about that, sidebar, guys. But it's the same thing with this potential new legislation in Texas. It basically concerns, we currently have a situation that says if a person transacts more than 3 wraparound mortgages in a 12-month period, they're supposed to be a licensed RMLO, residential mortgage loan originator, and their company needs to be licensed with the state, with the Texas Savings and Loan Administration. Got it. So we are. It's easy. Once you do that, you can still use an outside third-party loan processor to process your buyer. You don't have to do it yourself. And things of that nature out there. And really is a tracking mechanism for them. And again, I don't like that per se, but now what they want, because we created an entity that steps in between the seller and buyer. We call it OFN Lending. It's our wrap mortgage lending company, where we actually underwrite the borrower. We then draft the note and deed of trust in our names, and we take the liability off of the investor and put it on ourselves to make sure that the transaction is compliant under Dodd-Frank and the SAFE Act and all the things you got to be thinking about out there. And we'll assign the mortgage back to the investor. And even though that has worked for the last couple of years in Texas, they're saying that even though you do that, you still have to be licensed. And of course, what you find in the investor world here, and I think anywhere, is investors don't want to be licensed to do anything or registered or nothing. And so luckily the Seller Coalition Foundation out there, which is headed up by Eddie Speed, we've got a letter going out to the Savings and Loan Administration to present that to them, that we think it needs to be changed or other options are available than what they want to do. We'd prefer it just to go away completely, and we'll see what happens in that regard. But then I look at this in hindsight a little bit, and I go, is it a horrible thing if it does get passed? I don't like it. As I said, I don't like any government registration at all. I mean, we won't talk about politics, but I am a pure libertarian. Keep the government out of your pocket any way you can in that regard. And the same way in Texas with this, I prefer them not to do it. But 95 to 98% of my clients do less than 3 transactions in a year. There's a handful of guys that do more than 3 transactions, 5, 8, 10, 20, whatever it might be. And I guess that if you're doing that kind of volume, there's no reason. I'm not objectionable to being licensed. I mean, I went and got licensed. It wasn't a big deal. It's pretty easy to do and do it. But it does affect a fairly small percentage of people. Now, there may be a few more things within the scope of the bill I'm not up to date on right now, but that's the primary one I see. The other issue is the state digging up some old laws where they're now trying to claim that a wraparound mortgage is defined as a second lien mortgage. And of course, if you read the Dodd-Frank Act, it says it's a subordinate mortgage. And those are very different things. Whereas a second lien, is typically a lien for purchase refinance by a borrower. That's a legitimate second lien from a third-party lender. And of course, they want to, again, put a square peg in a round hole, which I don't like that at all. And the reason with that is there's some stipulations that if your interest rate exceeds 10%, which again, most wrap loans don't exceed 10% right now, but as interest rates are rising in the marketplace, your wraparound rates have to rise as well. And I think the only real negative issue with that is that the borrower cannot be required to pay a servicing fee. Okay, that's $35 a month.
Right.
If you adjust for it in your mortgage, raise your interest rate by 1/16 of a point or 1/8 of a point, pass it through that way if you want to do it. There's always a reasonable solution to solve that problem out there. And change your terms a little bit and have the seller pay those servicing fees. So there's a few things that are out there that are, on the horizon. And the key again is if you don't fight it, they'll just keep walking all over you, I think, is the real answer.
Was there anything in particular that triggered the legislative push or the push to try to suddenly regulate?
I don't know at this point. The first part of what I was talking about this, if you did 3 or more transactions in 12 months, was permeated by one guy out in El Paso. And they tried to pass the law in 2018. And what this fellow was doing was he was selling houses to Hispanics coming over the border. And they'd come over the border with this pocket full of cash. You get this big down payment. Wouldn't, take an application or anything on these people. They'd all default. He'd foreclose, kick them out, and go sell it again, right? It was a racket. And eventually, the legislator there got wind of all that, which is probably appropriate, and tried to change this and put this into effect in 2020, and it didn't happen. It didn't pass. But in 2022, it became effective. And in those kind of situations, and you see that kind of activity needs to be regulated because that's simply the wrong way of doing business. And, in this investment industry, like anything else, guys, as lawyers, there are good lawyers and there's not so good lawyers. In the investment world, there are good investors and not so good investors. And it's getting those bad actors out of the equation, I think is not a bad thing to do if you can somehow. Just like with us and the state bars that we are under, they don't want these guys who take advantage of people to practice law per se. But, I haven't heard what may or may not have precipitated, this change at this point in time. I haven't seen that out there yet.
All right. If you're just now joining us, this is the Creative Finance Collective. We're taking creative finance questions. or real estate questions, industry-wide topics, feel free to ask those, post them in the comments. We'll get to those. We're on as long as we're getting questions. We do have another question from a YouTube user and listener. What typically happens when the seller files bankruptcy after they sell subject to?
Sean, you want to take it? You want me?
Yeah, assuming that the transaction was through a warranty deed transfer where the buyer is now the record title holder, and assuming that you're outside of the 90-day voidable preference period, and it was a bona fide transaction, then nothing happens. If there is an amount owed by the buyer, let's say the seller financed a portion of the equity of the property, so it's not just a performance note or performance mortgage, but there's an actual amount that's owed to the seller. That promissory note would be an asset of the bankruptcy estate, and could be sold to a third party, but you would just continue to make payments as normal until told otherwise. But they can't, it generally will not impact or affect your ownership of the property. Now this isn't something that Scott would probably address because Texas doesn't really allow for it. But here in Arizona, if the subject to transaction were completed using an agreement for sale, or some states call it a land contract for deed, then that potentially could be subject to being set aside because it's an executory contract. And that really is the biggest risk of those types of transactions, is the future bankruptcy risk by the seller. And there's a whole formula that would have to be put in place to figure out how to put the parties back in the status quo, so that the purchaser was basically put back in the same position they were prior to the agreement for sale. It involves fair rental value and all kinds of stuff. But nevertheless, if it were transferred by warranty deed, and you're outside that 90-day voidable preference period, likely nothing would happen.
Yeah. And just to add to that, Sean, first and foremost is making the assumption that the seller did not sell the property in order to try to hide the asset to a friendly third party.
Right.
Where you have hundreds of thousands of dollars of equity, you transfer it to a buddy subject to, and
Right.
that can be voided out by the bankruptcy court in those
Correct.
scenarios.
Yeah. It has to be an arm's length bona fide transaction.
Yep. And if it is, and what's funky in the bankruptcy court and the mortgage world is the seller no longer owns the asset. It's been sold. Let's say it was sold a year or two ago. They file bankruptcy. Things happen. Things change for people. Got it. You're in hopes that that mortgage loan has been maintained current properly by the person who bought the property subject to that debt.
Right.
So that when a bankruptcy is filed, the great odds is they're going to include the underlying debt in the bankruptcy in some format. But the property is no longer owned by the bankruptcy estate at that point in time. The debt obligation has been quasi-transferred to the buyer and being maintained. And so the great odds are nothing's going to happen at all.
Right.
But the lender may, through some format, find out about it. Things can happen. It's just the nature of the beast. And through that, could they call a loan due? They could, just like at any other point in time in that business. But again, I think if the loan has been maintained properly, as Sean said, if it's a truly arm's length transaction done properly outside of the time frames that are there, the great odds are the court is not going to unwind it. There's not going to be any issues. Just keep making your payments, move forward, and it is what it is. Because why worry about something you have absolutely zero control over? I mean, these bankruptcy courts are the most powerful courts in the country, really. They can do pretty much whatever they want to do. And if they want to unwind that deal for some reason, I guess they could do it. They just don't do it, though.
So let's modify the hypothetical here a little bit. Yeah, you know, Sean, you qualified a lot of your statements with with a number of assumptions. One of them we just discussed, that it's an arm's length transaction. But what happens if it's in that 90-day voidable preference period? So the transaction happened less than 90 days ago. What happens then?
The trustee can apply to the court to unwind the transaction. Frankly, the trustee probably wouldn't even start with an application for the court. Unfortunately, I've had clients who have had, were able to garnish money or different things during, the 90-day voidable preference or before the bankruptcy filing, only to have it filed. And next thing I know, I'm getting a letter from the trustee. Hey, that was within 90 days. We need to claw back those funds, and or we're going to pull you in front of the court. And we've had to send them back. Unfortunately, one time I had gotten paid out of those funds, and that really was a bummer. But in any event, they'll probably send a letter to the buyer basically saying, okay, it was within the voidable preference. Here's what we propose, and give you a proposal on how to unwind the transaction and what it would look like. And then you either can say yay or nay. And if you say nay, then they're going to pull you in front of the bankruptcy court, and they're probably going to prevail. And so you generally, work with them to try to, give the property back. Unfortunately, if it's within those 90 days, there's really no limitations on, clawing back assets into the estate.
Yep. I'll make a comment too for the investors out there that we all go in the investor world. We go in front of the JP courts for evictions and small claims and things like that from time to time. Got it. Pretty unassuming. Maybe you go to county court for an appeal on an eviction hearing. Got it. Sometimes you get sued and you got to go to a county court, maybe a district court for some action and whatnot. Got it. But when you walk into the bankruptcy court, which is a federal court, I don't know what it is, but everything seems to change a little bit, because these federal bankruptcy judges, they've seen a lot, they've heard a lot, and they don't take any guff at all from anybody. I mean, it is, you better be on point. You better have a good bankruptcy lawyer with you there to help you navigate things and handle scenarios. I will, never forget, we had a vexatious, shall I say, resident on a house where I had gotten called in. My client, before I was his attorney, had sold a property using, I don't know, I'm trying to think how to even describe this. It was a 2-page document called an addendum to a lease. There was no lease, but it was titled lease option, and it was a little 2-page document. But the guy had been in the house for 4 years, and this was back just after the real estate crash. I'm sure this seller had to get out in trouble. This guy wanted to buy. Anyway, the guy he was a year behind in payments, and so he went to JP court to try to evict. He won. It got put up to county court for an appeal, and it got kicked out because the court said it's an executory contract. And in Texas, after 4 years, you've got to foreclose. I get the phone call, analyze it all, appoint our trustee, go out. I accelerate this thing. The guy files bankruptcy. He gets thrown out of bankruptcy. We repost the property for foreclosure again, and COVID hits. But guess what, guys? We weren't under any of the orders not to foreclose, so I foreclosed. I had full authority. I think there were 3 of us down at the foreclosure auction that day. Now we go to JP court. again, we win. We go to county court. We win. Guy goes to the Court of Appeals. You're going, you're kidding me. Then this happens. Finally, we just get tired of it, and we file a declaratory judgment action in district court to claim that he has no ownership in the property. It's been extinguished, wiped out. I think somewhere along the way here, guys, I had actually refinanced the first lien mortgage for the borrower, and that lender foreclosed on the property, which wiped out everything. And he files bankruptcy again. And this time in bankruptcy court, he has a lawyer, and the lawyer is up talking. The guy gets up, pushes his lawyer aside, gets to the podium to address the court. And I mean, you can almost see the hairs on the back of the judge's neck stand up. And it was over faster than you could blink. She was going to have none of that, and she was done. I mean, it was a pretty quick judgment at that point in time for us, and he was eradicated from court, and it was over. But in the bankruptcy court, they're serious. They don't take a lot of stuff off of you, and you better be prepared because you're in out pretty fast usually. But they follow the rules and regulations right down. And when I say they're powerful, man.
Yeah. All right. I have another question. Two questions that are related and follow up from each other. So I'll just kind of put them together. I keep hearing about transaction coordinators. How should a TC be utilized? If I hire a TC, do I still need a lawyer? Question mark.
I
guess start with what are they and how should they be utilized?
I find it funny, guys, that going back about 2 years ago, the TC didn't exist in the creative finance world. They've always been out there in the traditional realtor world, but they didn't exist in our world. And all of a sudden, the gurus start to teach that, Mr. Investor, you're so important. Your time is so important. You need to hire a transactional coordinator to do all the detail work for you so you can go out and do the more important work. Well, ergo, TCs come into play all of a sudden. And what I saw and still see is the blind leading the blind so often. Because so often the investors who really want to get involved in this business aren't as proficient as they should be. I know we've had these conversations before here, and they think that these TCs know everything. And oh my goodness, guys, they don't, unfortunately. And I know there's people out there who try to teach TCs how to do better and be better and those kind of things. And I think there's a learning curve that is getting better. It's still not there yet. And I think the investor just needs to decide, do they need a third party to help them do the work along the way? For instance, in my world, in my companies, I don't need a TC. I know what to do, know how to do it. I can get it done pretty quickly. I might spend an extra hour or so on a project getting it done, and that's it. But do I need that TC to coordinate all this kind of stuff? Now, I will say I deal only in properties in my own backyard primarily. I'm not a California investor buying a house in Florida or Ohio or Georgia or Carolina or wherever it might be, where maybe you do need someone to help do some more communication for you. And maybe if you really are out there rocking and rolling in the world, knocking down, high volume, you need help to get this stuff done. So there's I think a time and place for all of that. One thing I saw is sometimes I see TCs, though, who want to validate their utilization. And I was looking through a package from a TC, and they had all of these letters going to various people, going to the HOA, going to the insurance company, telling the HOA how to do things, telling the insurance company, this is what we want you to do. Going to the mortgage company, doing the same thing. And I'm just going, guys, you're not going to tell the HOA how to do their business. That's why they have a resale cert, transfer fee, and those kind of things. Just because you send them a letter doesn't mean they're going to change anything they do. In the insurance world, you better know how to set up insurance properly. And just because you tell the insurance company to do X, Y, or Z doesn't mean they're going to do it. And the same with a mortgage company. It's like you're opening cans of worms that you don't need to be opening out there. So I think from the TC's perspective and the investor perspective, it depends on who is the investor. What kind of time? I mean, do they have a full-time job? They don't have any time to do the business that they need to be doing? Okay, the TC could be very viable. Are you doing high volume where you don't have time to deal with all the details? I can see where the TC can be advantageous. I just think you need to make sure you need to know more than the TC knows to make sure that they're doing the right thing along the way and interview them. And I don't see that happening too often, unfortunately.
Well, that I think the key. What you just said, Scott, is they need to know more. I think about an interesting corollary. Sean, I think will appreciate this. Sean and I saw this a long time ago when we were much younger lawyers, but even now, as we have a firm, one of the things that we make new lawyers do, because it is when they go file a lawsuit, they need to start it from the beginning and do all of the things that in big law firms they wouldn't normally have to do. Like go down to the court and file the thing. Like go get a summons issued. In other words, we ran into so many lawyers that, we're like, here, prepare this, hand it off to this person, and they'll go do it for you. And then one day, this lawyer's stuck at 10 p.m. at night with an urgent filing, and they've got to go, and the statute of limitations is about to run at 12 p.m., and they don't know even where the court is, much less how to go file that after hours, right? They've been relying on other people that they suppose knew how to do that, and they did know how to do it. A good legal assistant paralegal does know how to do that. But what we realize is how can you direct and how can you tell the people that are working for you what to do if you don't even understand the process yourself, if you don't even have an appreciation for it? And I think your comments, Scott, is I think a lot of people think, oh, I can go get this person to do a bunch of stuff for me that I don't have to go spend the time to go learn to do myself. And I'm just going to rely on them to do it right. And maybe you get lucky and they know how to do it. Or maybe they're a coordinator that's looking for direction from you in order to do it right. And that's where really I think nightmare scenarios can happen, is if you're relying on them to fill in your knowledge gap, right?
Oh, amen. I'll go back to 1996. Andy, were you born then?
Yeah. Yes.
Okay. Barely. No. But we were closing 400 plus properties a year at that time. And I looked and I said, why are we throwing away 400 closings a year? Yeah, we're buying houses and whatnot, but why are we throwing away all this title work? So I said, we're going to start a title company. Do you think for a minute I had a clue what a title company really? I knew the title process to a certain degree. I'd closed enough deals. I knew the paperwork. Do you think I knew the process or the step-by-step steps along? I didn't have a clue. Luckily, I had a young lady in my office who had been in a title company. She was an escrow officer, and we decided we'd do it. And she knew how to get things set up and going. And you have to learn from the ground up. Everything from how to operate and run the title company, the rules and regulations of that title company, the Department of Insurance, the operating systems, all the things you got to do. The curative process that you have to deal with for various liens that come up along the way. But as you said, Andy, when you do things yourself and you got to learn all this stuff, guess what happens? You learn the business, right? And you get to be good at it, I hope. And then you're able to, parlay that to other people to take over. And you can then direct it from afar a lot better than others. Kind of like Sean does from afar up there in Wisconsin, I think. I'm kidding. But, I don't know how you do something and teach or know what someone else is doing if you yourself don't know it, as you said.
Right. Sean, the last piece of that question, I think it's a pretty obvious answer, but does the transaction coordinator replace the lawyer? I don't think so, right?
Well, and this is one of my biggest pet peeves. I'll see on social media, or whatever, somebody posting, "Hey, does anyone know an attorney in this state, or an attorney here, or attorney there?" Or I need an attorney in this state, and all of a sudden they get peppered with sales pitches and comments from transaction coordinators like, "Hey, I'm in this state, I can help you." I'm like, "You're an attorney?" No, you're a transaction coordinator. They're asking for an attorney. They're not asking for a transaction coordinator. You can't provide legal advice. And in addition to not being able to provide legal advice, in Arizona, there's 3 people or licensed individuals who, for compensation, can prepare or even fill in legal contracts or documents. That is, of course, an attorney. The second is a certified legal document preparer, which is a subcategory or kind of like paralegals, but it's what we call certified legal document preparers. And they have to pass some tests and go through training and be approved by our Supreme Court. And then the third is licensed agents who are doing it in conjunction with a real estate transaction where they're representing one party or the other. That's it. Transaction coordinators cannot fill in, even if it's a pre-printed form with the information there, where you're just kind of filling in the substantive terms and putting the meat on the bones. You can't do that. That is the unauthorized practice of law in the state of Arizona. Now, you can, without either a real estate license or being an attorney, you can work behind the scenes and communicate with the parties and push paper here, push paper there. Escrow comes and says, "Hey, we need an operating agreement from the buyer." Okay, "Hey, buyer, I need your operating agreement. I need to get that over to title." They can do all that and coordinate that, and that's it. A coordinator. They're not a contract drafter. They're not an attorney. They're not a licensed real estate agent. So, I think I know there's TCs out there that are overstepping those boundaries. And even to the point of charging for consultations and advice, and it's like, that's legal advice. Those are legal consultations. Why are you charging for that? And so it is one of my biggest pet peeves, the fact that people are actually out there looking for legitimate legal assistance and advice, and all of a sudden they're being pushed to TCs. I also know that there's individuals out there that call themselves paralegals, and they're not licensed as certified legal document preparers in any particular state, but they call themselves a paralegal because apparently they worked in a law firm at some point, who then say, "Oh, I can assist you." It's like, you're a paralegal, and your paralegals generally aren't licensed. Yeah, you worked in a law firm, but that doesn't make you an attorney. That doesn't make you someone who can provide legal advice. So yeah, the answer is, if I hire a TC, do I still need a lawyer? Yes, you still need a lawyer, because only lawyers can fill in the contract. Unless you're going to fill in the contract yourself, then you do need a lawyer to fill in the information on the contract, or even not fill it in, draft the contract. Make sure that you're not violating any state required laws. We talked about this morning on the podcast, but for example, Colorado has a provision that if you are going to go in and you're going to buy, it doesn't matter if you're buying it subject to or any other mechanism. If you are simply buying, even if you're paying full fair market value for that property, if you're going to go in Colorado and you're going to buy a property where the seller's loan is 31 days past due, there are tons of disclosures you have to provide. You have to give a right of rescission, and there's required statutory language that has to go into that contract, or you're violating Colorado law and can end up in with civil penalties and maybe even criminal proceedings. Now, the one exception to that is if it's an owner occupant who's buying the property, then it's okay. But if you're going in as an investor and you're given a smoking, you're buying it, arm's length, fair market value, the whole thing, you're bringing cash to the table and it's in default 31 days, you have to make those disclosures. So if you, I mean, chances are if you're hiring a TC, they're not going to know that. They're not going to understand that. And they're not going to know that in every single state. There's 50 states, that you have to understand and appreciate the laws on. And my recommendation is for every state that you're purchasing properties or buying properties, selling properties, transacting in real estate, you should have an attorney in that state who works with you to put your contracts together for that particular state.
Oh, Sean, you're dead on point, Bubba. I was just talking about that exact same thing at lunch today. These so-called foreclosure rescue laws in various states that you better know what's going on because, some may be a 3-day right of rescission, some might be a 30-day right of rescission, and everything else in between and different penalties if you don't do that. And I get why they're doing that in order to protect sellers or at least give them an opportunity to rescind if they wind up able to refinance the property or get out of that foreclosure somewhere, somehow. I get it. But TCs out there, I see them practicing law without a license. I've had it happen several times and you kind of go, whoa, time out. And so often though, the investor, they just want to get the deal done. They don't care. And the TC doesn't care. They just want to get the deal done, get the deal closed, put money in their pocket, move on. And there's never a problem, guys, as we all know, until what? Until there is a problem, right? Mm-hmm. And then it's a problem and it becomes a big problem. And so many investors haven't been there yet. They haven't done enough volume to get there. But if you hang in this business long enough, guess what? Things happen that, we have to deal with and contend with along the way. And, you really just want to see TCs, there, as I said earlier, there's a time and place for them. I get it for everybody. And each investor is a little bit different. I think if you're doing your very first deal, you need to learn how to do it yourself and at least get it, under your belt, what the step-by-step process is along the way. And Andy, you were dead on point on your comments about it. And you really just want the TC community to I'd rather see them push that type of scenario instead of being the end all of end all. Part of I think the question this person is asking is, do I need the attorney? I don't know if they need attorney representation per se, but you're going to need someone to close your transaction who can prepare the paperwork, as you said, Sean, for that closing properly. The TC can't do it. Mm-hmm. I guess they can do it. They shouldn't do it. In Texas, you now have to close these type of transactions, which is a subto or a wrap of any type, in a law firm or in a title company, or it's void. Not voidable, it's void. I've actually run into 2 of those in the last, 6 months or so. You're going, are you serious? You close this at the kitchen table? It's like, yeah. It's like, yeah, can't do that. So if you don't know this, you stub your toe along the way. So again, time and place for the TC, I think, is out there based on who the investor is and the needs. But I also think that knowledge is power along the way as well.
Good information. All right, we have another question from a YouTube user. And I think there's a little miscue in the question itself or a typo, so we'll try to read through it, but or answer the question we think's being asked. When buying subto deals, are there times when a land contract would be better than an LLC? I think by land contract they might mean land trust, or it could be interpreted. When is a land contract better than like a wrap transaction or something like that, right? I mean, that might be another way to. If the land contract is like a land installment contract, if that's what we're referring to. But why don't we assume that they're talking about a land trust versus an LLC? Is there any time you like the land trust over the LLC?
Well, I'll take that because, again, conversation at lunchtime again today, with a local Arizona investor, this came up. And I find it interesting in the guru world, people who want to sell you a land trust or a land trust package or whatever it is they're trying to do out there. They want to use the words anonymity and things of this nature. And I look back in my career, I've done thousands and thousands and thousands and thousands of houses. And I have never one time worried about anonymity anywhere. Because philosophically, if you're doing things right, you take care of things right, you don't have a problem. Problems can occur. And if you're in a land trust or not, something happens negatively, a good lawyer is going to pierce that trust. They're going to find you, and everything's going to be disclosed anyway along the way. But other than anonymity, a lot of people think that a land trust somehow gets you around due on sale, and it doesn't. Unless it's a legitimate financial planning trust, a land trust is just another vehicle out there. And I do think that there's a time and place that investors, I think, can utilize a land trust, which is if it's going to be a fix and flip, if it's going to be a rental of some type, or if they're going to live in the property. If you're going to do a back-end wraparound mortgage, the sale from a trust to a back-end buyer is a due on sale violation. You're just kind of wasting your time with a land trust in the middle at that point. And I can probably get into a lot of other issues here that get into some legalities and some pros and cons, which I'm going to kind of pull back on a little bit and not get into right now. But there's a time and place for it. But it's really, recognizing, why are you using a land trust? What's the purpose? And do they really know why they are using it? The granddaddy in the marketplace is Ron LeGrand right now. Who's been around forever and 3 days, I think. Good guy, smart guy. And he likes to push a land trust on every deal, but he primarily deals with lease options. And I get it. And those kind of things. I think it depends on what you're doing, when you're doing it. And there's a time and place for it, I believe, along the way.
Yeah. Sean, do you have anything to add to that, or?
No, I'm not big on. I'm like Scott. I'm not huge on land trusts. They don't, for anonymity purposes, they don't work in Arizona because you have to disclose the beneficiary of the land trust. And then second, I've seen a number of times where these land trust gurus are basically pushing the trust and having it formed the wrong way, meaning they're having the seller set up the trust. So they're the grantor / settler of the trust. And then they're having the seller put the property into the trust that they've created. And then at that point, they swap out the beneficial ownership of that trust. There's two problems with that. The first problem is the seller then remains in control of that trust because it's a revocable trust. And then the second problem with that is the trust and any property put into the trust by the settler / grantor by state law, pretty much uniformly throughout the country, remains liable for the debts and obligations of the settler or grantor for their lifetime. So, you do this deal, a month later, the seller's out there driving, God forbid, they hit and kill somebody. Huge lawsuit, judgments entered against the seller. Guess what? That judgment can attach to the trust and the property put into the trust.
Yeah.
There is a way to set it up where you, the buyer, create the trust and you make like your LLC, the beneficiary, etc. It's complicated. It can be done and it can be done right. But you have to make sure it's done and done right if you're going to do it, number one. Number two, anonymity may work in certain states. It doesn't work in Arizona because every time we convey, state law requires every time the property goes into or out of a trust, you have to disclose the names and addresses of the beneficiary. And you're not going to make the seller the beneficiary of the trust at any point. And so at the end of the day, you know, they can serve a purpose for certain types of transactions, and they may be useful, but I would say for 95% of the investors out there, they're just more, they're expensive, they're cumbersome, and you should just form an LLC and take title in an LLC.
Yeah. And I prefer that myself, Sean, just like that. But they always want to make it seem like it's a one size fit all, you know, no matter what state you're in. And it's not that way.
Yeah.
Right.
Or it's a one situation fits all.
Right.
All right, guys. Well, we've hit basically about an hour and we're out of questions. So perfectly timed. We'll go ahead and call it for the day, but appreciate you taking the time to be with us, and we'll do it again next week.
Well,
All
gee,
right.
let's go outside and let's roast.
Good night, everyone.
Yeah. Turn on your AC. We'll see you next